Welcome to the 2020 Lakeland University Constitutional Day Address. My name is Joe DeCecco. I was a state prosecutor in this county of Sheboygan for 27 years, the last 14 years as the elected district attorney. I've also had the pleasure of teaching a criminal law course here in Lakeland University for about 10 years now. I've titled this presentation, The Constitution. Are you kidding me? What were they thinking of? I use that rather provocative title because there are some things in the Constitution which are, to put it kindly, kind of strange. And I want to go through just a couple of those things in this presentation. To start at the beginning, we had, 13 original colonies. They were British colonies. And they got upset with their mother country, and they decided to take on the most powerful military and naval force in the world at the time. And you would think they wouldn't have much of a chance, but they actually won. They actually defeated Great Britain, and now had the problem of trying to figure out what form of government did they want to institute. The Founding Fathers had a very deep fear of autocratic leaders. All the leaders that they had known to date had been kings or shahs or czars or emperors, all autocratic despots. And they did not want to have that in this form of government. They did not particularly want to trade a foreign tyrant for a domestic despot. And so they were very afraid of giving a central federal government too much power. They feared that in the hands of the people that ran that government, they might very well be looking at the type of government they had fought against. So they got together and came up with something called the Articles of Confederation. The Articles of Confederation were did have a federal government, but its power was extremely limited. Under the Articles of Confederation, the federal government could not levy taxes, couldn't regulate interstate commerce, it couldn't pass laws concerning domestic affairs, it couldn't establish a national currency, it couldn't do a lot of the things that we take for granted that governments do today. In fact, what essentially the Articles of Confederation created was 13 sovereign, independent states that were held very loosely together by a national government, but that government was severely hampered because in most of the decisions that it made, those decisions had to be approved by the 13 states. And it didn't take long for people to realize this was not going to work at all. You got to realize that this was a torturous process. Before the Revolution, the 13 colonies, they really didn't get along very well. During the Revolution, they got along well enough because they could spew their venom on Great Britain. But after the Revolution, when they became independent, all this bickering returned. And so it was very difficult to get 13 entities together to agree on something. But the Confederation certainly was a failure. And so there was another meeting, a constitutional convention, to try to devise a government that could govern the country properly, but also would not have too much power. It would not turn into the type of governments that the Founding Fathers had experienced around the world, into an autocratic type of government. So they sat down and had a constitutional convention. I should note that some of the states, including my native state of Rhode Island, didn't even send a delegate there. That's how fractious this unity between the states was. And so they sat down and they hammered out what today we know as our Constitution. It was a unique document. It formed three separate branches of government. The legislative branch, which is Congress, the executive branch, which is the president, in his various agencies, and the judicial branch, which is the federal court system. All in all, the Constitution contains 7 articles, or just parts of the Constitution, and eventually the first 10 amendments, which we know today as the Bill of Rights, and from which we derive all our constitutional powers, our constitutional protections, our constitutional rights, all come from the Bill of Rights. So I want to talk about one aspect of the Constitution that is a little concerning. And it's a little, when you first learn about this, it's kind of shocking. And that's the Electoral College. The Electoral College is in Article 2 of the Constitution. Article 2 establishes the presidency, the executive branch. But what it also does is establish the way in which the head of the United States, the president, is elected. Now, you might think in a democracy, well, whoever gets the most votes by the populace wins. And that's not quite true with the Electoral College. I don't think a lot of people know that when they vote for a presidential candidate, they are not directly voting for that presidential candidate. They are voting for a state elector who will represent their wishes to have that particular candidate elected to the Electoral College. So why do we have this? Why did the Founding Fathers think we needed an Electoral College? Well, one of the reasons was, and I don't really quite understand this, one of the reasons was that they didn't want the states with the larger populations to dominate in the presidential election over the states with the smaller populations. You know, to me, this doesn't make much sense. It's the states don't cast one vote for president. The people in the state cast multiple votes for whomever they choose. And so I don't quite understand why that was one of their reasonings. Another reasoning, which is even a little bit more disturbing, is that the Founding Fathers believed that not all voters were well informed enough to vote for the leader of the country. I'm not sure what they meant by that. These men were highly educated, and most of the country wasn't. But in a democracy, and we've lived through this, you vote for the person you want to be president. It doesn't matter how well-informed or how ill-informed you are, you have the right to cast that vote. One would hope that, voters would get as much information about a potential candidate before voting for that candidate, but that's not required. That's not a requirement of the Constitution. The only requirement is that you be eligible to vote. So how does the Electoral College work? Well, let me give an example of California, for example. It has 55 electors, and by the way, the number of electors a particular state has is determined by the total number of senators, and of course each state has 2, and then the total number of representatives. And that varies from state to state because of population. So California has 55 electors. What that means is that one elector actually represents about 712,000 voters. Now you look at Wyoming, Wyoming has 3 electors. And that equals out to one elector representing about 195,000 voters. There's a big difference between the power of electoral votes as compared to whom they represent. So the concept of one person, one vote counting in a presidential election doesn't really apply to the Electoral College. So you might be asking, so why does this matter? I'm still voting, even though I'm voting for a state elector, I'm still voting for the person I want, and they're going to vote for the person that I want them to vote for, which is true. What's the big deal? Well, the big deal is that we have had 5 presidential elections in our history in which the person that won the Electoral College did not win the popular vote, 2 fairly recently. That's a little disturbing. How can, in a democracy, someone win the popular vote but not win the Electoral College vote? And it's because of this proportionate type of scenario. In 2000, Al Gore received the majority of votes for president, but he wasn't elected because George W. Bush received the required votes in the Electoral College and Gore did not. In 2016, Hillary Clinton won the popular vote, but Donald Trump became president because he outvoted her in the Electoral College. So even though there have only been 5 instances in our past, in our long history as a country, these instances seem to crop up once in a while, and it's kind of disturbing. People kind of scratch their heads and say, wait a minute, Hillary Clinton got 3 million more votes than Trump, and Trump's president? How does that work? Well, it works because of the Electoral College. There are attempts and movements to try to amend the Constitution, Article 2, that establishes the Electoral College so that it's eliminated. So that just like with governorships and attorney generalships and senators and U.S. representatives, whoever gets the most votes wins. Simple as that. But until that is amended, until the Electoral College is changed, taken out of the Article 2 of the Constitution, we must continue to do our presidential elections this way. Amending the Constitution isn't easy. I think our founding fathers really didn't want someone, for example, to think, okay, let's make Thursday coffee day. Yeah, let's put that in the Constitution. Every Thursday's coffee day. Well, they wanted to keep that kind of frivolous and inconsequential stuff out of the Constitution. So they made it difficult to amend the Constitution. To date, we've had 27 amendments to the Constitution, which includes the first 10 amendments to the Bill of Rights. But it's difficult to do. So, for example, the way it's usually done, there are different ways to do it, a couple of different ways, but the way it's been done mostly in the past is both the House and the Senate, by a 2/3 majority, must recommend a constitutional amendment. That is, they both must recommend the same constitutional amendment. If that occurs, then it goes to the state legislators, and each state must, 3/4 of the states that exist at the time the amendment is proposed have to ratify it. And then it becomes an amendment. And this takes time. In our history, we've only had 2 amendments that cancel each other out. We had the 18th Amendment, which was prohibition. It prohibited the use, the selling, the transporting of alcoholic beverages. And that was interesting. And the 21st Amendment, which repealed it. Americans really liked their whiskey and beer, obviously. Unfortunately, it took 14 years from the time the 18th Amendment was ratified until the 21st Amendment was ratified. 14 years. And during that time, to be honest, organized crime, particularly Italian organized crime, flourished in this country, became national. I don't think there's been any other country where a government action has so prompted organized crime to flourish. Okay, well, except for Putin's Russia, leave that aside. But prohibition was really a bad incentive to really push organized crime in the United States to the level that we saw it in the ensuing years. Now, one of the other quirks of the Electoral College and its requirements was this. So the person that receives the most electoral votes, and there's a threshold they have to receive, becomes president. But in the original Constitution, whoever gets the next highest number of electoral votes becomes vice president. So you got 2 guys really running against each other. The winner becomes the president, the loser becomes the vice president. Now, in the first election, George Washington won the Electoral College, became president. John Adams had the second highest number of electoral votes. He became vice president. And that wasn't a big problem because while George Washington never really declared a party, he did believe in a relatively strong central government, federal government. Adams was a Federalist, and that party believed in strong central government. So that was no big deal. And then in the next election, Washington was reelected, and so was Adams as the vice president by the same method. But then after 2 terms, which was 8 years, Washington said, I think I've done enough of the country. I'm going home. And Adams ran for president. And he won because he got the most votes in the Electoral College. And Thomas Jefferson, who got the second most votes, became the vice president. But they weren't from the same party. Adams, as I said, was a Federalist, and Jefferson was known then as a Democrat-Republican. I have no idea what that means. Don't try to translate that into Democratic and Republican parties today. But the difference is that while Adams believed in a strong central federal government, Jefferson in general believed that the state should have the power. And so there was an inherent conflict there. And it wasn't until 1804, the 12th Amendment, that the Electoral College portion of the vice presidency and presidency election changed. It changed so that state electors, instead of voting for 2 people for president, now voted for a president and a vice president. In effect, it created the presidential ticket that we know today, Trump-Pence, Biden-Harris. And that was probably a pretty good thing because without that amendment, without that change, John F. Kennedy would have won the election in 1960, I believe, but his opponent, Richard Nixon, would have been vice president. George W. Bush would have won the election in 2000, but Al Gore would have become vice president. And in 2016, and you probably should buckle your seatbelts for this one, Donald Trump would be elected president, but Hillary Clinton would have been elected as the vice president if the 12th Amendment didn't exist. I don't even want to think about that combination in the White House. But fortunately, the 12th Amendment does exist. And so we have tickets today. Instead of having simply the top 2 contenders who are fighting against each other, one becomes president, one becomes a vice president. Inherent in this system of government was something that the Founding Fathers would call checks and balances. They did not want any one of the 3 branches to become dominant over the other 2 branches. And they knew there was a possibility of that. They know what people are like. They know what power does to people. And so they tried to build into the Constitution this system of checks and balances where one of the branches could cancel out something that another branch did if it exceeded its powers under the Constitution. And so you have, for example, Congress passes laws. The president can veto those laws, and it won't become law under a veto unless Congress overrides a veto by 3/4 votes of both houses. And that's happened in the past. You have the president given the power to appoint federal judges, including United States Supreme Court justices. But the Senate's been given the power, under the advise and consent clause, to ratify or confirm that appointment. If they don't, that person does not take their judicial seat. And so there are a number of these different checks and balances within the system. This doesn't, by the way, prohibit attempts by different branches of the government to usurp the power of other branches. It doesn't entirely prevent them from going outside the bounds of their authorized constitutional power. And it's not, some people say, well, we're in a constitutional crisis today, or, last, 10 years ago, we're in a constitutional crisis. We've had these since the beginning. And one of the first ones, and I kind of title it Presidential Shenanigans, was when John Adams was president. Remember, he's vice president for 2 terms, then he becomes president for 1 term. And then Thomas Jefferson, who was his vice president for Adams' term as president, then wins the election for the presidency in the next term. So Jefferson wins the election. But the term of office that the president takes office, and at that time, did not begin until March. The election was in November, but the term of office didn't begin until March. And so you had, in essence, a lame duck president, for lack of a better term, for a number of months. And the terms of senators and representatives that fell within the cycle of the 4-year elections also didn't begin until March. And so you had a president who was not going to continue to be president, and you had a Congress that was not going to continue to be Congress. In fact, Jefferson and his Democratic Republicans not only won the presidency, they also pretty much wiped out the Federalist domination of both houses of Congress. Adams sees this, and he really doesn't want to see Jefferson and his party in such control of things. So what he does and his party does is they pass a Judiciary Act which creates a relatively large number of judicial districts, including magistrates. And this passes because, again, the Federalists are still in control of Congress. And then Adams proceeds to appoint judges and magistrates to these newly formed positions. And what happens is that they go to the Senate. The Senate, Federalist Senate, confirms them. But there's a process to be followed. That process is that the Secretary of State has to apply the seal of the United States, the Great Seal of the United States, to these appointments. And what happens is that before all of these can be processed in that way, Adams is out of office, and his Secretary of State has the Constitution to do this. They don't affix the seal to some of these appointments. And so when Jefferson comes in and he appoints James Madison as Secretary of State, James Madison will subsequently become a president. But Madison's Secretary of State, Jefferson says to Madison, okay, don't process these appointments. If they don't get processed, they don't exist. Even though they're lawfully done, they were created by Congress, which the federal districts are allowed Congress to do that, even though they were confirmed by the Senate, albeit a Federalist Senate. Don't process them any further. And so one of those guys' name is Marbury, and Marbury decides he wants his job. He was appointed. He was legally appointed. He was confirmed by the Senate. He wants his job. So he brings suit in the United States Supreme Court. John Marshall is the Chief Justice. And one of the things that John Marshall had to think about was that if he had the power to order Jefferson and Madison to process that document, Jefferson and Madison could simply ignore it. How could it be enforced? There's no Supreme Court police to go out and make sure that whoever's ordered to do something does it. And in fact, Jefferson purportedly said, okay, let's see Marshall make his decision and let's see him enforce it. So Marshall did something which is really unique. He determined that the previous Judiciary Act, not the one in question, the one before it, that gave the Supreme Court the power to issue what we call orders or writs of mandamus to the president, that was confirmed by a congressional law, but it wasn't in the Constitution. And so Marshall said, okay, that law, that part of the law that said, that which was the Congress saying that the judiciary had this power, is unconstitutional. They can't do that. Only the Constitution or an amendment to the Constitution can do that. And so Jefferson kind of got what he wanted. Marbury didn't. But that particular decision, that's the decision called Marbury versus Madison, is an extremely basic concept to the power of the judiciary, that the judiciary can review laws of Congress to ensure whether or not they are in accordance with the Constitution. That was the first time that was done. And it gave the Supreme Court, and that power is recognized today, it gave the Supreme Court a very definitive check on the power of one of the branches, even though it was, in essence, expanding judiciary power. Anyway, so we've talked about checks and balances, and we talked about some of the early stuff. And I just want to finish up by letting you in on something that's kind of disturbing. There's a lot of disturbing things about this stuff. Our system of checks and balances, the one we've been talking about for a little bit, it's a voluntary system. It requires the three branches to, one, recognize what their constitutionally authorized powers are, and as importantly, to recognize what their constitutionally authorized powers aren't. And throughout our history, we've had these little tussles where one branch has kind of pushed the envelope against another branch. And our government and our system has survived these. They eventually are pulled back. But the intriguing thing to me is that the preambles of the Constitution says very clearly who's in power of this government. It begins, we the people, that's you and me. We're the ones on whose behalf this Constitution was established. And by ourselves, we don't have a lot of power. We don't have the power the president has, or even, the Speaker of the House, or the Senate Majority Leader, or any of the cabinet members. We don't have those kind of powers as individuals. But together, we have a tremendous amount of power. Together, we have the power in voting to ensure that the people in elected office, whatever office that may be, are responsive to constitutional duties and requirements. We have the power of free speech, so we can speak out against. We have the power to redress grievances to the government. We have the power of peaceful assembly, so we can protest government actions that we think are illegal or unconstitutional. And it behooves us to do that from time to time. We're the ones that really have the power in this country, but we have to get together to use them. Without that, without us every once in a while, we need to exercise those powers to make sure that the promises of the Constitution, which remain unfulfilled to this day, are met. Thanks for listening, and stay safe.